Sorry, was it too fast?
No, no, ma'am.
I feel like they are two independent provisions and they can be, taken up simultaneously, irrespective of the fact that I have gone on appeal for a revocation on the cancellation. I think still officer can still go ahead with because there is no bar on 63 on account of these proceedings.
It's because, ma'am, there are two proceedings. One is relating to cancellation, and second is relating to the assessment order under Section 63. So, if I file an appeal, the demand is stayed, not the operation of the order. And this view can be taken, although a contrary view can also be there that supposedly tomorrow appeal authority states that the registration was not proper, cancellation of registration was not proper. Then what happens to the demand which has been created under 63? Supposedly the appellant has not been able to file an appeal. So whether it would be rectified under section 161 and what would happen. So these are two different two things which can go together, and yet the clarity has to be made.
Correct.
Because similar scenario happens in when supposedly a person has crossed the threshold for composition. So the law requires a separate order to be passed for the taking out of composition, and second is a separate order is required to be passed for the arriving at the demand. So supposedly a separate order has been passed for taking out of composition, and the appellant files taxpayer files an appeal. Then what happens to the demand which has been created? And so these are the issues which are yet to be decided. That what happens when one of the order has been passed and subsequent order is for the creation of the demand, since the two orders cannot be passed together and separate forms are required to be taken.
Right, sir. It needs to be tested. We'll go with the first case study. Mr. X is running a tea shop. Notice was issued under ASMT 14 based on UPI payment details received by proper officer. Assessment was done from FY 2021 to 24-25 based on UPI data, and order was passed in ASMT 15. Whether action by proper officer is correct under section 63. So this, I think, whole of Karnataka, we have seen this notices issued all around based on UPI payments. And they were subsequently withdrawn. All these notices were withdrawn. So what is the view of members on this? Because there is no evidence against tax liability. It is only a suspicion. UPI data, whatever is received, is some receipts. That does not mean that is taxable. Supply has happened in the first place. So whether a 63 assessment can be done under this case. I could not find any High Court order where it was challenged, though this notice was issued during July 2025 across, so many different vendors, like, from a Pani Puri vendor to a tea vendor to an auto wala. So all of them received such notices, but none of which were taken to High Courts. But it was subsequently withdrawn.
Soumya, just a basic question. So even if they want to go for appeal, what is the issue they will be disputing? Like saying the best judgment was wrong, or the officer does not. Anyway, officer has powers, so they cannot take this matter on that fact or that issue, right?
Mm.
So only
Right.
if at all, if they want to take it to appeal, only on the best judgment part they can go, right?
No, the assessment under 63 itself, I am questioning whether you can take up such kind of a assessment based on, how you decide whether that person is a taxable person based on UPI payments. I mean, what sort of a reason to believe that you have that that person is a taxable person? So it starts from there. How did you arrive at that question that he is a taxable person based on UPI payment? Whether UPI
Can that
payment,
foundation itself can be appealed? Because when officer has some powers, but still he can do it.
yeah, that was what was done. But the degree of evidence or the degree of proof that I am a taxable person from a UPI payment is very, very less. So an assessment under 63 cannot be initiated based on that kind of data. If it was challenged in High Court, maybe they would have quashed all these notices straight away. But before that, the government itself withdrew all these notices. And in this case, I also, draw your attention to this Karnataka Chinmaya Seva Trust, where a batch of 40 writ petitions were challenged before Karnataka High Court, where this was under the service tax era, where notice and order were based on third-party data, the 26 AS. This or the trigger for all these proceedings was an MOU between CBDT and CBIC for data exchange, where the CBIC received 26 AS and ITR filings of the various people, and based on that, notices were issued, saying that we have noticed 26 AS, some entries are there, and based on that, notices were issued and whether they were correct. So this was a single judge writ petition which was disposed, and does not cannot be used as a binding precedent. But what came out of all these proceedings was that that even though notices can be issued, but the contentions are kept open for both sides, and adjudication only based on evidence, and adjudication only demand can be confirmed. So all these 40 writ petitions were remanded back to adjudication for fresh findings. So it does have a significant persuasive value for similar situated, that it can be litigated, need not be accepted, and you don't have to pay the tax just because a notice was served to you based on some third party data. So any views before we move to the next case study?
Yeah, this
Soumya.
Yeah.
yes.
My view, sir. Yeah, please.
Yes, sir. Yes, sir.
So my view is that it is strictly speaking per se not beyond the act, but it is not a judicious use of power. It is just a notice. The noticee can reply, but it is not a judicious use of power. If it results into an order or any demand later on, that could be another issue. But till the notice stage, it is not beyond the GST Act, but it is not a right way to go ahead. Yeah, judicious way.
But my question is, the burden of proof is on whom now to disprove this, that 26 AS is actually equal to a taxable supply under GST or service tax. The burden of proof is on whom?
Sorry, what does the section say? We can refer back to the language of the section. What is the strength of the basis which they should have before issuing a notice? Is it a reason to believe it is appears, or what is the similar type of a language? What is the strength of the language being used in the section? We'll have to fall back to that to test this part.
Yeah, actually 63 just says that a taxable person or a person whose registration is cancelled. So I think the key word
Not
is
this
taxable.
part, the other part.
Which one?
Subsequent part. But who is liable to the proper officer may proceed to assess the liability to the best of his judgment for the relevant tax period. So, but he has to give an opportunity of hearing and all that. So at the initial stage of giving an notice and opportunity of hearing, it does not say there has to be a.
So this portion is belonging to this, this all has to
This
be
is
read
up to the
together.
registration part only.
No. Whose registration was cancelled, but who was liable to pay tax. So that is to be read
No, it
together.
is not about whose registration was cancelled. It is about the person who fails to obtain a registration,
Yeah, so it is
even
a
though
taxable
liable to
person.
do so. So the officer's view is that, yeah, the person is uh, should have obtained registration. The person
Yeah.
was bound to do so. Since he has not done so, so I'm issuing a notice that this information is available with me, and based on that, this notice is being given to you. So please substantiate, or we will go ahead and pass the best judgment assessment. But it is not a judicious use. It should not be done. We very well know. I believe, if I'm not wrong, in Telangana, the limit is 20 lakhs only for goods also. They have not increased it to 40 lakhs like most
Correct.
of the major states. So if you just break that 20 lakhs into, ma'am, monthly sales and the daily turnover of even a fruit cart, it is definitely crossing that. So we can't say, but yeah, that is not the intention. Everyone does not want to bring the cart sellers into the tax net, etc.
Yeah,
So we are just into part whether it is illegal or whether is ill advised to carry out such things.
correct. Yeah. But I felt that the evidence cannot be a mere UPI payment or a 26AS entry. It should be much beyond that. And they should have evidence to say that it was a taxable supply before
Ma'am,
issuing the show
so
cause.
my view here is that for best judgment, this evidence is not the test. It is just an information. If it is an evidence, then it is not going to be a best judgment assessment.
No, the amount can be best judged, right? It is not the case that, the taxable person or not itself is best judged. Best judgment is the amount, the quantification only.
Right, ma'am, right. We can proceed. I've just presented my point. We just don't need to argue it. You can give your side and we'll move on.
Yeah, sir.
Just sharing my thought.
Yeah, definitely, sir. I'm also thinking along with you. So I feel that,
We
I
can
mean,
proceed.
just to add one thing from my side, that in my opinion, see, UPI, payment based on UPI is an information. That is, there is no question about it, but that by nature it is an information. But for the information to become an evidence or a source of allegation against me, there has to be an inquiry which has to be conducted. And it cannot be a case wherein information is just put across me that in on the basis of this information I feel that you are liable to pay tax and you have not paid the tax. So the proper course would have been in such cases, because I don't challenge that this information cannot be used. It has to be used, but then it cannot be a case wherein neither the act contemplates like this, that an information can just be put across in the notice and the burden is on the assessee to prove that this information is correct or incorrect. When someone is making an allegation against me, at least he should be confident that he has made a correct allegation based on the information against me. If supposedly tomorrow I go and ask him, sir, why on the what basis you have treated this as a taxable turnover, he does not have an answer to that. He would just say that on the basis of receipt you have received. So that is not an answer. In that case, a inquiry has to be conducted to bridge the gap between an information and evidence, and that inquiry can be done either by Section 70 or Section 151. So the proper course in the cases wherein Karnataka, the notices were issued on the basis of UPI, I guess the process which was not followed for converting the information into evidence by conducting an inquiry, that was clearly the basis. If they would have taken the information from the UPI and issued a summon under Section 70 or a notice under Section 151 based upon the approval taken from Joint Commissioner, then I feel that the notices which were issued would not have been dropped or would not have been challenged. So, in my opinion, yes, UPI or 26 years can be used as an information, but not as an evidence, because not every receipt or not every income is a supply, and the onus is on the officer, even if he have issued the notice, to just to say that on what basis he has treated this as a supply, and for that answer he has to conduct an inquiry, and that inquiry, the process of inquiry is there in the statute under section 70 of 151, because every notice which is being issued in GST, the onus would always be on the officer, except for matters pertaining to ITC, to discharge the burden that this is the evidence on the basis I have treated this as a taxable turnover. So this, in my opinion, this bridge was not there in Karnataka, and that's why they were struck. They were dropped.
Correct, sir, correct.
And sir, as they have not followed the due process, and one of my client has received that, and he was basically a doctor, as well as he was selling the medicines, and whatever the payments have been received through UPI, that was not offered to tax as such. So based on that, they have received the notice under 63, and we have replied on that. But after that, we have not received anything, how they are concluding or as they passed. But because of this, at least the people have realized the relevance of that and started taking a registration and trying to comply. But as on date, we can make out that based on that UPI, at least those people are identified by the department, and possibly in the future time, they are going to check whether they are registered or not registered, or else they are going to do the inspection on investigation as the case may be. Sir. Because
Yes, ma'am, there's
when
no
they,
challenge about the relevance of the information. It is completely
uh,
relevant. It is
yeah, sir.
completely relevant.
Only,
Because
yeah,
one similar matter which we are facing here is regarding the OYO rooms,
mm,
wherein an information has been obtained from the company, and company has given an Excel sheet wherein they have said that this particular hotel has booked so many rooms on our portal. And on the basis of that information, notices have been sent across the entire state that you have crossed the threshold and you have not declared the proper supply. What we said that you have obtained an information, you have not checked the veracity of that information. This is a third party information. Okay, na? From where you have obtained the information, how this has been deemed as correct, because this is our admission register, this is our invoices, these are the admission register is a legal document. The person whom you are saying that stayed in a hotel is not there mentioned in the register itself. So that means an information cannot be treated as an evidence merely because it has been received from a third party. The credentials have to be checked, and then it has to be put across the person that this is the evidence on the basis of which we feel that you are liable to pay tax. So this bridge has to be done, and merely it cannot be bypassed that there was a scarcity of manpower or scarcity of the time, and we were not able to conduct an inquiry because they are making an allegation. They are treating me as a culprit that I have not paid the tax.
Yes, sir. And one more thing is the 62 use the word as relevant material which is available, and they have used the word or which he has gathered. So the department were trying to look into this word in 62, in 63, and that is missing, which is there in 62, sir.
No,
So
but
they,
if we go through Rule 100, which is for Section 63, it mandates that the grounds on which he has been treated to be a taxable person, that has to be provided. And
actually.
one thing I would like to add to is that in Section 161, there is a proviso, third proviso, which states that no opportunity, no adverse action can be taken without giving a proper opportunity of hearing. So in that case, Madras High Court has interpreted that this third provision is only applicable wherein a suo motu rectification is proposed to be made, and not in case wherein an application has been made by the taxpayer for making the rectification. But at the same time, they observe that even though it is not there in the statute to give an opportunity of being heard on an application made for rectification by a taxpayer, still it is an inbuilt responsibility on the officer to follow the process and give him the notice of opportunity and then pass the order. So so similarly for 63, even if they are not using a specific word for 62, but it is a notice making an allegation that I am liable to pay tax, but I have not paid the tax. So again,
Hmm.
the information which has been used has to be given as an evidence, and how that information has been treated to be a supply, that has also to be given. Yes, it cannot be a 100% confirmed, but at least the reason should be there.
Got it. Yes.
Yes, ma'am. So, ma'am, we can.
So, yeah. So the one other point that I wanted to raise here is, see, here the notice was issued for 3 years or 4 years clubbed together in one single ASMT 14. So is that permitted under 63, or, a single year-wise notice has to be issued for 63? 2021 to 24-25 were clubbed under one single notice. So whether they can be clubbed as such? This is another one point we'll quickly discuss and then move on. Because it is a best judgment assessment, whether officer is permitted to club multiple years in under one notice.
I think they're doing that only now for most
Yeah.
of the best judgment. Yeah, consolidated. Yeah, I think that should be fine according to.
But
That
even
is
though
the
the time limit for issuing each of the years are separate and distinct provided in the section itself, taking a strict view, I feel like the notice should be distinguished for each year, for each tax period, and then issue. But otherwise, in practice, they are, clubbing everything, putting it together. So the other, because of time issues, I'll share this PPT after this, and there are two other case studies which are similar, which you can go through. One last case study I will take on e-way bill matter of an unregistered dealer. So he was moving the goods being unregistered with a bill of supply without invoice and e-way bill. So can an officer issue MOV 7 or a 63 proceeding has to be done? Because 63 is only purely for unregistered person. Compared to any other provision under the GST Act. So I just wanted we'll have a small deliberation on whether e-way bill cases can be issued to an unregistered dealer. Your views, members.
It can be. It can be
Because
done.
MOV provisions and e-way bill provisions are only on a registered person.
No, like he is an unregistered dealer and notice is issued to the ICT hardware or recipient.
Yeah, the ICT hardware is an unregistered dealer. He was unaware of any of these provisions of GST. He moved the goods and he was intercepted by the roving squad. And he was issued notice in MOV 7. But he is an unregistered person. There is no registration that is obtained. There is no tax invoice. There is nothing. However, the officer, while moving the goods, let's say it was areca nuts, and by looking at the goods, he knows that the value of it is more than 1.5 lakhs.
Because 129 says, notwithstanding anything contained in this act, it says, as well as it use the word where any person transport any goods.
129.
Yes. Because
So
in
can a
few
best
cases,
judgment be done under 63 also, or only upon interception he can only pursue with 129?
when there's a specific section 68 and 129, I think they have to look into this aspect only, because they are intercepting at the time of movement of goods.
Yeah. So any person who transports a good, so that way, if you look at it, then MOV 7 stands valid.
Yeah.
However, 63 also can, but 63 cannot be invoked during interception.
Yes.
Once it is
Later on they can.
intercepted,
Yes.
so MOV 7 only can be issued.
Yes.
Okay. With this, I conclude 63. Any other closing points on 63?
No, one thought came to my mind with respect to the unexplained credits, under income tax. When you declare something, when they discover something, and then can that be linked to the GST? when something is accepted by the assessee, can it be linked to the GST and can this section 63 be brought into it?
No,
Person
that's
has
what
not-
happens whenever they are relying on third-party data. It is similar to the same thing that they are having some information, as Arpit sir has already put it. That is, they are in possession of some information, but a notice cannot arise in vacuum. There has to be an investigation or a proceeding or an inquiry, and based on that, they have some finding, and only then the show cause notice is valid.
No, for 69 also, generally what happens is there could be a scenario where they compare the production, what should have been happened for in case of manufacturing company, the capacity and then the actuals declared. And where there is a discrepancy, then they say, okay, this is an unexplained thing. You have beyond the capacity, you have produced and sold. So can that be used as an evidence for 63?
But is he an unregistered person? Because a
Yeah,
manufacturer-
unregistered. Yeah,
Unregistered.
unregistered.
Yeah, I think that also comes under 63 only.
Okay.
If he's unregistered, definitely 63. So can we move on?
Yes, ma'am.
Yeah.
Because we have only 15 minutes. So section 64.
Yeah. So we quickly cover summary assessment. So summary assessment is unlike to the 63 assessment, where an order is issued first, and then you're given a time to reply on that order. Unlike 63, where 63 is starts with a notice, ends with an order, but 64 is like an emergency provision where an order is issued, and then you are supposed to reply within 30 days. So quickly we go through the 64 provision. The proper officer may on evidence, so he should have some evidence that coming to his notice, and has to obtain prior permission of the additional commissioner, joint commissioner, proceeds to assess the tax liability to protect the interest of revenue and issue an assessment order if he has sufficient grounds to believe that delay will adversely affect the interest of revenue. So there is some sort of an emergency. It's emergency in this case to issue an order urgently, provided that where a taxable person to whom liability pertains is not ascertainable. The taxable person is not ascertainable and it pertains to supply of goods. A person in charge shall be deemed to be the taxable person. So deeming provision is given in proviso. On an application made by taxable person within 30 days from the date of receipt or on his own motion, the additional commissioner or joint commissioner considers the order is erroneous, he may withdraw and follow the procedure laid down in section 73 or 74 or 74A. So he can go through the regular provisions once he feels that this emergency order is not applicable. So these kind of cases I have seen where, person is already in liquidation and you want to, get something recovered. So urgently you just issue an assessment order. So you fall under as secured creditor, and the resolution professional will take care of your order liability also. So that is about section 64. So the main prerequisite is they should have some evidence demonstrating tax liability and sufficient grounds to believe that immediate assessment is necessary to protect revenue, and with the prior approval of assistant commissioner, joint commissioner, an order is issued, and then you are given a time to respond to the notice. So the rule is rule 100 subclause 3, which provides that order will be issued in ASMT 16 and the withdrawal can be made in ASMT 17 within 30 days, and after which an ASMT order withdrawing or rejecting will be issued, and further proceedings can be initiated under 73 or 74. I have just put a screenshot of the ASMT 16 form. So the 16 form states like this: it has come to my notice that unaccounted for goods are lying in stock at godown. on a vehicle station and so, you are not able to account for these goods or produce any document showing the details of the goods. Therefore, I proceed to assess the tax due to such goods as under. So, my question to you all is it this summary assessment under 64, is it confined only to goods or whether it is applicable to services also? And whether it is on taxable person or it is an only unregistered person or registered person also. Summary assessment. So 2 questions. Whether it is for goods and whether it on whom can it be issued or initiated. I put the the basic provisions in front of you for your thought process.
See, this section has a lot of deviating fictions here. One is they are trying to basically, according to me, it is basically for the goods, what I understand with my reading on that. And second is they are trying to bring out, for example, like if the transporter is carrying the goods and they are not able to ascertain who is the owner of that goods, then in that case, the person who is in charge of that goods will become as a taxable person. So that is
Correct.
also a fiction in this section actually. This has to be used only in the case of exceptional circumstances.
Right.
That's the reason they have used the word very strictly as permission of additional commissioner or joint commissioner. There should be a reason to believe, and whomever they are going to issue this notice, they have to assess that there is a evasion of tax, and accordingly they have to proceed under 64. So according to me, this is only for goods is my reading.
Yeah, when the notice which has to be issued under this provision is clearly providing goods, even though the section doesn't say that. The section nowhere clearly says that it is only with respect to goods, unaccounted goods. But the notice itself is providing for only that. So we can, I think,
provisional is,
safely assume
yeah.
that it is only with respect to unaccounted goods.
Because they have used the word as person in charge of such goods. He can be a transporter or warehouse keeper, whoever it is.
Yeah. So in
such
the
person.
previous example also what I had given in that case of ICT hardware where he was moving the goods without invoice or registration, this summary assessment can be easily invoked because this provision allows for issuance of notice to a taxable person. So which means a registered person as well as a person liable to be registered. So both the cases are attracted. So the officer can invoke MOV 7 provision or he can also invoke this 64 summary assessment as well, in my view.
But ma'am, MOV 7 is separate. It is a penalty for not carrying the goods with the documents. And this section 64 is assessment. So in my opinion, both of them can be invoked simultaneously. One for the levy of penalty for transporting the goods without documentation. And second is assessing the liability because the person was liable to be registered. So this is the one point in my opinion. Second, whether 64 is applicable only on goods, if that would have been the case, then the proviso would not have been written that such liability pertains to supply of goods. Because if 64 main provision would have been applicable only for goods, yes, the form states so, and from there we can infer intention that it is only applicable for goods, but then the main provision is not restricting because the proviso is only restricting for the pertains to supply of goods. If if the main provision would also have been only for goods, then pertains to the supply of goods word would not have been there in the proviso.
Right. Yeah. That is taken, sir. Yes.
And
Because,
I think, sir, one more point here. Specifically in 64, they have used the word on any evidence. If you see here, on any evidence showing a tax liability of a person coming to his notice. So I think together, if you are reading this, and why they have given a provision is to give an explanation to 64. One is my reading, sir. And specifically, they have used for the goods. They would have used even the provision for services also. Something if they have to come out for anything as services, they would have come out. Why they have given provision only for goods? That is also
Because
one
ma'am,
more.
in that what happens is supposedly goods are being moved from say Rajasthan to UP, and it is moving through Delhi. Now there are no documents available at that time, and the only person who is present before the officer is the transporter. So in that case, where the liability is because there is no document pertaining to goods, and the only person is the person in charge of the vehicle. So in that case, he would be treated as an owner, and then he would be assessed. So the proviso only makes a departure for the purpose of that. Subsequently, the owner might not challenge, the transporter might not challenge that I was not the owner, so why I was assessed. So the proviso is only creating a situation wherein the owner cannot be identified, and the only person is before the officer is the owner person transporting the good, that is transporter. So in that case, the assessment would not fail.
Yes. So in case of unaccounted goods lying in a warehouse, so the warehouse operator will be issued this notice for summary assessment.
Yes,
Because,
because 67(1) also states that the
Yeah.
owner of warehouse makes him liable, 67(1) for the purpose of inspection.
So if he is not willing to, disclose
Yes.
who the owner of the goods is, then the notice will be issued under his name.
Yes.
Yeah, so my view is that this section covers services itself, but since the machinery provision for invoking this section is not available for services, so that is rendered, it can't be used for services, it can be used only for goods, since that machinery is. So tomorrow, if they amend that notified form, then of course it can be used for services also. So only thing is machinery provision is not there. Second is this is not a notice as ma'am started with. This is just straight away an order. But there are two very strong thresholds. So my request to everyone is to give adequate weightage to these things. It says first, of course, one is that permission from an additional or a joint commissioner or senior officer should be there. The other one is that there should be an evidence. Evidence is on a very high pedestal. Whether officer has reason to believe, wherever that is used, that is on a lower pedestal than evidence. Where it is used, it appears to. So that it appears to, like in section 73, that is even lower than having a reason to believe. And where it is just an information is available or something is available, that is even lower than that. So we should not check everything at the threshold of the evidence. And where evidence is specifically mentioned, we should not think in terms of having reason to believe. Reason to believe may not be a sufficiently evidence if it is properly tested. So we have to keep those things when we are reading these sections in mind.
Sir, one more
Correct, sir.
point here, sir. As RP sir was also saying that both they can initiate 64 and 129. Can we not say that 64 itself is giving the term as liability? They have not used the word as tax liability in the provision. Though in the main provision they have used the word as showing any evidence showing a tax liability of a person. But whereas if we read the provision, sir, it says where the tax liability to whom the liability pertain is not ascertainable. Can it not happen that 64 can go with the interest and penalty, and only 64 can be invoked because they have said they have sufficient grounds to believe that any delay in doing so may adversely affect. So 129 will take its own time of 15 days or 7 days as the case may be. So because of that, why only 64 cannot be invoked and why 129 has to be invoked along with 64?
Then,
This is
when 64 is about, it talks about tax liability. So that is
Hmm.
about tax liability. So tax liability can arise only if there is an underlying supply. Just because the goods are lying in a warehouse or they are on board a vehicle, it does not have a sufficient evidence to state that it is a supply. Just the presence of goods there. So when the officer says that there is an evidence of tax liability, in GST, the tax liability cannot be imposed without there being a supply. So officer must have evidence that these unaccounted goods are
Yeah, sir. So 200
Supply,
times.
they are a supply and there is a tax liability. And 129 provisions are just penal provisions for violation to follow any provisions of the act or the rules. The specific provisions are given there in the act, the section 68 and the rules regarding the movement of goods. So that is only regarding that. That is not about tax liability. Remember, initially the tax liability was
Initially it
used
was
there,
tax
then it
and
was
then
removed.
they made it. Yes.
Because 129 cannot impose tax liability without there being an underlying supply. So that was the basic test was failing there. That is why that was the underlying reason why that was removed. And this is about tax liability. So it should be the tax liability should be there and the evidence should be there with the officer. And the third condition is that it should be there is an imminent danger of that revenue would be lost or something like that. So all these have to be tested before passing the order. That is why the checkpoint instead of the notice being there is that
Order.
a senior officer itself would do there. And since there and I believe that these provisions have been taken from erstwhile state VAT tax laws. So similar provisions were there, I've been informed. And like it happened at many sections, some were copied from Customs Act, some from Services
Yeah, sir.
Tax Act, and some from Goods.
Yeah.
So this was taken from there itself, and the form was also designed and notified for goods only. Though the section reading does not restrict it to goods only, but that is,
Okay.
to my belief, the reason behind all this.
Okay. Okay.
So, Gurjit Singh sir well summarized provisions of 64.
Yeah.
One quick case study before we wind up on 64. So, this is a XYZ manufacturer of generating switches at Hosur. Petitioner is an assessee under the state tax authorities. Investigation was conducted as per the proceedings of the Joint Commissioner on 29th March 25. The issue was ineligible input tax credit on goods lost destroyed under 17(5)(h). They saw some destroyed goods in one corner of the factory and they thought that there is so much of wastage in production, and they adopted a 2% wastage based on physical examination, and right from 1819 to 2425 they passed an ex parte order under section 64. So whether this assessment is correct under 64, and what are your views on this? Whether such summary assessment can be done for 17(5) for ineligible input tax credit. Of course, following all the requirements that he has evidence that there is tax liability, and he has taken the approval of the additional commissioner and joint commissioner, and he proceeds to issue an assessment order. But the form per se says that, it has come to my notice that unaccounted goods are lying in stock. This form is not proper for this. And therefore, I feel there may be some inconsistency while issuing a summary assessment in this case for input tax liability versus output tax liability for goods.
Yes, ma'am. In my opinion, for the purpose of arriving at the ineligible ITC, section 64 cannot be invoked. It has to be invoked only for the purpose of arriving at the output liability.
Correct. Perfect, sir. Yeah. So this can be initiated under 74
Yes.
itself.
Yes.
Pursuant to investigation,
Yes, ma'am.
74 proceedings can be
Yes,
initiated.
ma'am. Yes, ma'am.
Yeah. So to summarize, 63 and 64, the targeted audience for 63 is unregistered or a registration cancelled person versus a registered or an unregistered person. Urgent situations for 64. SCN is mandatory for 63. Whereas for summary assessment, this is a direct order in ASMT 16. There's no prior approval that is required for 63, whereas prior approval of additional commissioner, joint commissioner is required. Mandatory hearing is given under 63. No hearing is, warranted or given in 64 because it is only an order itself. So there is no question of any hearing or opportunity of being heard. The time limit is 5 years for 63, whereas there is no such time limit that is specified. It is urgency driven. There's no time limit that is specified at all. And appeal can be preferred under 107, whereas ASMT 17 application has to be made within 30 days. I don't think the summary assessment order is an appealable order. So with this, we conclude. I want some closing remarks from Arpit sir.
No, ma'am. Yeah, it's an honor to have you, and it's an honor to have a vote of thanks for you because you have taken 2 marathon sessions on section 63 and 64. And the best part is that we have discussed on the nitty-gritties of, as Guji sir said on section 64, the word evidence has been used. As Annapurna ma'am, you also said that section 62 uses a different threshold and section 63 uses a different threshold. So these are the nitty-gritties because these discussions not only helps us in understanding the scope of 62, 63, 64, but then the larger perspective, the entire statute as well. That what is the threshold of evidence or threshold of burden which is there on the officer to discharge before issuing a notice under a particular section. Previously also Ashwin has taken also on section 73, 74 on the usage of the word term appear. So the legislature itself is putting a different threshold for evidences and the burden on the officer, and that is what we have to see. And whenever the matter comes, we have to argue basis upon that. So the discussion aspect on section 63, 64, which you have taken was par excellence, and it was really a engaging discussion on these provisions. And since I am the host today, so I would request Guji sir for the vote of thanks.
Arpit sir, can it be someone else like Ramji sir is there or Annapurna ma'am himself?
So
Yes,
Ramji sir, if you can
my request.
give the vote
Yeah,
of thanks for today.
Yeah, it's my great pleasure to give the vote of thanks for this to Madam for having excellently taken us through the sections 63 and 64. It's always a pleasure to be part of the SMS. Thank you, Madam. Thank you all for joining us.
Yeah, I also
Thank you,
thoroughly
everyone.
enjoyed sharing my views on this, and thank you for all for joining today.
Yeah,
Thank
ma'am,
you.
full appreciation for the efforts you have taken and the interest you took up to cover each and every point. Though we started today's morning that we will discuss 64, but since some points regarding 63 were not covered, you were very keen to cover that also. So hats off to you for that dedication which you showed, ma'am. Thank you so much.
Thank you very much, ma'am. Thank you.
Thank you,
Have all
Soumya.
a
Thank
great
you.
weekend. Yeah, bye.
Yeah, thank you, Dr.